floor is. My Lords, can I just go back on one point that I made this morning, not to make further submissions or anything like that, but just because I made a mistake in relation to where the term conventional is used in the patent. And I failed to notice that at paragraph 16, the term conventional is also used in relation to figure 1 and figure 3. So it says figure 1 is a drawing showing a response signal spreading method, brackets conventional. Figure 3 is a drawing showing a CQI signal spreading method, brackets conventional.
Yes, I see.
Going back to where we were just before a short adjournment, which is the judgment.
Sorry, Ms. Lane, and they are conventional, are they?
Well, we say the skilled person, yes, they are conventional.
I know you say they all are, but the figure 1 and 3.
Yes, yes, I don't think anyone is going to say they're not conventional. Going back to IPCOM and Vodafone and turning now to how the judge dealt with that in his judgment in a bit more detail, because I gave you a preview prior to the short adjournment, we didn't go into all the relevant paragraphs. It starts at paragraph 282, so we're at bundle core 5, core tab 5, page 119. And it starts at paragraph 280, where obviously there's a reference to IPCOM and Vodafone, and then at 281 it talks about what the claim issue was, and the fact that the form wasn't exactly the same, but it was to the same effect. Now, at paragraph 282, it says that the base stations in the alleged infringement could not, in normal operation, send the required information. They would need reprogramming to do that. And we say that that is wrong because, as we've seen in IPCOM and Vodafone at 116 and 117, and it's probably easiest to just look at those in the judgment because those paragraphs are cited at the top of core bundle page 122. We have the point of the factual point on the appeal. And at the end of 116, Annex 2 refers to changing the settings of the base station, does not mention reprogramming, whereas the body of the judgment refers to reprogramming. And then in my judgment, the language which the judge used in Annex 2 is more accurate. So in fact, changing the settings is what was going on, not reprogramming. And so the judge has misunderstood that because he thinks that what's happening is reprogramming. And then, obviously, we've got the citation from the judgment, and I've already pointed out that, although it is a long citation, it doesn't start till 110. That means it misses out 107, which includes some of the factual background, which is important for understanding the factual point on appeal. And then at paragraph 284, it says, so the base stations were not set up to do things which would require reprogramming. And again, that's the same error. And perhaps what's happening here is that the judge is reading actually from the judgment at first instance, or considering the finding at first instance, in particular at the end of paragraph 225, which is cited in IPCOM and Vodafone at the top of 121. On the contrary, Vodafone's evidence shows that the change requires reprogramming. But of course, as we know from paragraph 117, the finding on appeal is that actually changing the settings is the accurate way to describe what was going on, not reprogramming. And even though it was only changing the settings, that was not equivalent to switching on and off. So we then get to paragraph 285, and the same error is repeated because there's another reference to requiring reprogramming. And then at paragraph 287, I agree that if reprogramming the Apple technical phones were required to achieve the result, then they would not be so adapted. That is what IPCOM decides, but it is not required. The phones have the necessary logic, etc. And so, because the judge has applied the wrong test here, which is asking whether or not programming is required, he hasn't considered the correct question. So the question he should have asked himself was whether the what was required was programming, adapting or configuring in order to put the logic into effect. And he just simply hasn't considered that question, and therefore there is a factual finding missing as a result. And we say, obviously, that in this court, my lords do have enough information to reach a factual finding on this. I mean, the same error is then repeated at paragraphs 288 and 289, which again talk about reprogramming. And so they're not asking the correct test, which is whether in normal operation the mobile phone was appropriately programmed or adapted or configured. And if the correct question had been asked, then the judge would have had to take into account that 2 signals must be sent, as we've seen in the technical document on essentiality, to cause a configuration change. And in that situation, then that has to be done before the code multiplexing structure of the claim comes into play. And so we say, therefore, the case is on all fours with IPCOM and Vodafone. And it is not on all fours with things like Philips and Nokia and just switching on and off. Sorry, Philips and Nintendo, I should have said. So what points to...
Sorry, go on.
Carry on. Optis says, well, never mind, you could just change the word reprogrammed in the judgment to reconfigured without changing the underlying logic. And we say 2 things about that. First of all, it recognises that submission, the fact that the judge has used the wrong test, because it recognises that reprogrammed is not the right word. It should be reprogrammed, configured, adapted, etc. And secondly, we say that you would have to change the logic because, in particular, in paragraph 287, as I've already pointed out, the judge hasn't dealt with the fact that configuration changes have to be made by the base station in order for the code multiplexing structure to come into being. And so it's an additional factual finding which the judge has simply not addressed.
And when you say configuration changes made by the base station, you mean the base station causes reconfiguration in the mobile?
Yes, yes, it has to send the signal to reconfigure the mobile because it has to send the correct parameters in order to ensure that the code multiplexing structure of the claims is used as opposed to another code multiplexing structure. Because as you'll appreciate, there are lots of different code multiplexing structures that could be used. Some examples are set out at paragraph 275 of the judgment, and not all of them fall within the scope of the claims.
So the base station has the ability to send mobiles instructions,
Yes,
causing them to choose between different instructions.
yes.
Does the choice involve a reconfiguration? Is it not just acting on the instructions it's been given to choose the particular structure in accordance with its programming?
Well, we say it's the same as changing the settings. I mean, we say that changing the settings is what was found to be the correct factual position in IPCOM and Vodafone, and this is changing the settings in the same way. And just like in IPCOM and Vodafone, at paragraph 117 of that judgment, where my Lord Justice Arnold said, it is true that the base stations were capable of altering their mode of operation so as to send the relevant signals as soon as their settings were changed, but without that change, the base stations could not operate in Annex C mode. We say exactly the same thing applies here. The mobile phone is capable of altering its mode of operation so as to act in accordance with the code multiplexing structure of the claim, but not until the two signals are sent.
The two signals are sent anyway. The only thing that changes is the value of the parameter, whether it's 0, 1 or 2 in one case.
Yes,
so
but
the signal is always sent. It's only a question of what the bit value is.
my Lord is right about that, but the signal is, the precise value is very important, because obviously, as my Lord will appreciate, if you don't send a non-zero value of NCS1, you're not even going to have a mixed resource block. And equally, you may well have a resource block in which every square on the grid is filled up with ACNACs. So you're simply not going to get the code multiplexing structure of the claim without the sending of signals of the correct value.
What characterises something as a configuration change? What is that? I mean, I may be wrong, because I, believe it or not, don't actually remember every detail of every mobile phone case I've ever had the pleasure of doing, but I'm pretty sure there are lots of instances in which base stations send instructions to mobile phones, like use channel X, for example.
Yes.
I wouldn't have called that myself until hearing this appeal a configuration change. But is it? And if it is, okay, do I take it that every instruction is a configuration change, or if it isn't? If there are instructions which are not configuration changes, what characterises the distinction? And I understand you say, I understand the factual. Your case is to draw a factual analogy with the facts of the Vodafone case, and say, if I look at the facts of Vodafone, I fall in the same side of the line. I understand that argument, but I'm trying to understand what the legal distinction you're drawing is. Why do you call? I know you call it a configuration change, but why is it in your case?
Well, my Lord, perhaps I can approach it from a different angle, and then my Lord will tell me I haven't answered the question, but let me try it my way first, which is, what we've got to start with is the test in IP common Vodafone, because that is what the law is.
Right.
So that test is appropriately programmed or adapted or configured. And the question you're asking is whether you have to reprogram or adapt or reconfigure or configure.
Okay.
And so IP common Vodafone is telling you that configuration changes are relevant.
Yes.
Now, obviously, then once you've applied the correct test, it's going to be a question of fact as to whether what you've got is a configuration change. But it is clear that configuration changes are something less than reprogramming.
Right.
So they are definitely
Or at
not
least different, one might say.
Oh, yes, different. So you don't have to write a whole new program, write a whole new sequence of programming language. You can do something else that is equated in IP common Vodafone to changing the settings. And so, I mean, the closest I can come to answering your question is to say, well, what we know about configuration is what IP common Vodafone tells us, which is that included within it is changing the settings. And we say that this is changing the settings.
So any change to any settings is a reconfiguration, according to your I understand you're perfectly entitled to, as you said, go to Vodafone and say the law is programming. Well, that's not going to help, because that's the point of this discussion. Adapted, that doesn't help either.
Yep.
So we're on configuration.
Yes.
And the question is, what is a configuration? And that's not answered by saying configuration. That's answered by the meaning of the word configuration. And my point is still there, that what I'm putting to you is that it feels as though you're saying that any change in a mobile caused by an instruction from the base station is a configuration. And I mean, maybe that is your case. I'd be surprised if it was, but maybe it is.
Well, my lord, it's clear that switching on and off isn't good enough.
Okay.
Because that is also effectively covered by the Philips and Nintendo case. And so if all you were doing is switching something on and off, then that wouldn't work. But we're doing more than that here, because we're sending these specific parameters which are telling the mobile phone, use a mixed resource block and use it with a 2 cyclic shift interval. And that is certainly a change in the settings, and I would say that is a configuration change.
Okay.
Use a different
So just forgive me for
Yeah.
I won't ask it more. I will stop at this point, but I just do want to ask the question again. If the base station tells the mobile to transmit on a particular channel, is that which is different from what it was doing before? Is that a configuration change?
Well, my lord, I suppose I might say it depends on the precise facts as to what this channel is doing, and but I don't think we can conclude from the case law that that is excluded from configuration change, because configuration change does seem to encompass things that are relatively straightforward, because they are things that allow something to alter the mode of operation basically instantly. I mean, that was the case in IP Common Vodafone.
Okay, thank you.
The root question in our context is adapted to.
Well, it's adapted to in the sense that that is the wording in the claim, but that's basically a type of claim which is called a means plus function claim, which is sometimes expressed by the words adapted to, sometimes can be expressed in other ways like set up to send, and so on. But the question being asked is, do you have to do programming or adaptation or configuring in order to get it to work? So I don't think the adapted to in my submission, the adapted to in IP Common Vodafone isn't referring back to the specific wording of the claim. It's referring to the type of thing that you have to do to get it.
But if you have in mind that you're looking to see whether something is adapted to do something, it's not adapted to do something if you've got to reprogram it. But you might think it was adapted to do something if it was ready to receive the instruction that would cause it to do something.
You might, but then you would read the judgment in IPCOM and Vodafone and see that that doesn't just talk about programming, it talks about adapting and configuring. And also, the other key part of paragraph 117, which I keep repeating, which is halfway down 117, it is true that the base stations were capable of altering their mode of operation so as to send the relevant signals as soon as the settings were changed. So there's clearly something already in there that means as soon as you change the settings, it starts working in this different way. And we say, yes, there is something.
It required a human intervention from the outside. Without the human intervention, they could not operate in the relevant mode.
Well, my lord, obviously, your knowledge of the details of the case is
it's
to mine,
set out
but
in 107. It all starts with the human intervention in an emergency situation.
But I mean, my lord, we don't have evidence here as to exactly what goes on. But in my
There's no human intervention here. The circuitry, to use the analogy of the mono and stereo, is there throughout. All that happens is that the base station sends the signal which tells the mobile whether it's mono or stereo.
But I mean, the mobile phone operators have to decide we want to use a mixed resource block. We think that the everything to do with the network is such that it makes sense to use a mixed resource block, because as we know, it often doesn't make sense to use a mixed resource block. So they have to decide.
It's not down to the mobile phone operators, it's down to the network operators.
Sorry, the network operators, I misspoke. So somebody has to decide to use a mixed resource block, and it's not a given that will happen. And then they have to decide which cells to use them in, and then they have to log in some way and create the script to do that, and then send that. And so we say there isn't any difference, material difference here, despite the fact that the summary has a series of 7 steps in it in IPCOM and Vodafone, because actually it's only step 5 that really matters, and that's changing the settings, which is the same as the step here.
So just to be clear, I can't follow you say that this is on the wrong side of the line for Optis's purposes.
Yes.
To take my Lord's example, suppose there's an instruction to change from channel A to channel B. Is a mobile reconfigured?
I mean, I find that difficult to understand because difficult to answer, because I think it would depend on the facts. But I mean, I can see that would be a much harder case to argue than this one. And in this case, we're talking about configuration, and changing from one channel to another might not be a reconfiguration. But obviously here we have got the configuration change because we're changing to a mixed resource block, and we are changing the cyclic shift difference. Yes, my learned junior is concerned that my Lord Justice Birss may think that every mobile phone case has this problem, but
No, I didn't think that. Don't worry, you needn't be concerned. Luckily,
Excellent.
I don't remember every mobile phone case, so it would be impossible for me to think that.
I mean, the point is, in relation to mobile phone cases, what the phone can do is affected both by its programming and how it's configured by the base station. And we say that it is relevant that IPCOM and Vodafone was a mobile phone case. And in that situation, it's understandable that the test referred to relates to both programming and configuration, because those are two aspects of mobile phone operation. And obviously the programming in the mobile phone is something that the mobile phone implementers to a certain extent are responsible for, whereas the configuration by the base station, the decision making lies with the network operators. So we do say that IPCOM and Vodafone was right not to simply refer to reprogramming, and also to refer to reconfiguring or configuring. And that is something that has to be taken into account. And it is clear that the judge was not considering those two separate things. He was only considering reprogramming. And in particular, as I've already said, he didn't ask himself the question of whether or not there was configuring or reconfiguring going on here.
Make sure I'm not making a mistake. This argument arises if you're wrong on construction.
Yes, exactly. So we assume that we've got this very broad claim, but you still obviously have to show with an adapted to claim that you don't need reprogramming or reconfiguration.
And just to clear one other thing out of the way, suppose you had the network set up in such a way that if X happened, the base station sent such and such a signal. It doesn't require any human intervention at all. the base station in circumstance X sends
Yeah.
signal A, in circumstance Y it sends signal B, and that causes the mobile to do a different thing, say swap a channel.
Yeah.
Is there reconfiguration then?
Yes, I mean we say that the human intervention doesn't make a difference. I mean, not least because on the facts of IP common Vodafone, I think I'm right in saying at paragraph 107, it explains that the reconfiguration or the change in the settings could be done manually, or it could be done by an automated script.
No, that's just how it was done. It still required a human intervention, even in circumstances where the automated script was the method by which it was done.
My lord, let me just check.
That's step 1 of Arrow 107.
So, I think what I was referring to was that the paragraph 4, Lima creates scripts, and then somewhere else, over at the top of the page, without Lima, an engineer would have to manually log in. And that's in order to send the commands at 5, which we say is the change in settings. So that could be done in an automated way at 4, or alternatively by an engineer manually logging in. I appreciate that what my Lord Justice Arnold is pointing out is that there is some manual intervention at the beginning of this process, but we say the important bit is stage 5, because that's where you change the settings. Or
But the reasoning was it didn't matter how it was done. It didn't matter whether you use Lima or, as in 108, alternative tools, or manually.
Yes. And we say equally, it doesn't matter in this case if it's done in an automated way or manually. I think that's dealt with the second point that I was going to make about what Optis
Can I just
said.
ask one more question?
Yes,
And I've certainly come across fewer mobile phone cases and remember them even less well. But mobile phones can receive instructions as to when to send signals, can't they?
Yes, yeah.
So suppose in the ordinary course of events, a base signal is communicating with a mobile phone in a way that affects when the mobile phone sends a signal. Is that a reconfiguration?
Well, my lord, it could be, and I mean part of the problem with these abstract questions is that we don't have the relevant patent claim
Yes.
in front of us, and obviously they all relate to specific patent claims, and so you have to understand what you're talking about. But I mean, potentially an instruction from the base station to the mobile of some sort, which isn't merely on and off, could be a change in the settings or a reconfiguration.
Yeah.
Is there a difference in meaning between the words reconfigure and reorganise?
Reorganised, did my lord say?
Yeah. Because I'm putting that to you because I don't think there is. And I'm trying to find a synonym or a way of ascribing a meaning to reconfigure.
Well, changing the settings seems to me a better description of it.
Then that asks the question is, what are settings? Which is why I'm trying to find a way of just focusing on the word reconfigure. But I mean, that's up to you.
Reorganise. I'm not sure that really.
See, my sense is that you're giving the word change. You're making the word reconfigure mean the word change. Any change is a reconfiguring, and I must say I have some doubts about that. Whereas to me, it has a sense of an organisational change, which is not the same thing as any change. And you can see why what was in the Vodafone case is a reorganisation.
Well, but this is just as much a reorganisation as
Maybe
that.
it is. That's
Because
it's okay. Then you win. I mean, that's not. I'm trying to just find a way of.
well, the problem is that reorganise is another word that doesn't necessarily have an obvious meaning, just like reconfigure.
Okay.
So I'm not sure, with respect, whether it assists, but I mean, certainly we'd say there's a reorganisation because they're using mixed resource blocks, and they are using mixed resource blocks with a 2 cyclic shift interval. And you know, as we've seen, that is a different way of doing things, which is only used in certain limited situations and not in the United Kingdom. And so, you know, it would be a pretty major thing, we would say, to be signalling those parameters and causing that to happen. I mean, it is not just an on-off switch. So, my lords, those were the points that I was planning to make, but I'm open to more questions, if that would assist. So that is IP common Vodafone and the adapted to issue. We now come on to the novelty squeeze. And again, for the purpose of this argument, we need to assume that the judge was correct on construction and also correct on the meaning of adapted to. And first of all, we need to look at the disclosure of Nokia. And Nokia is in the supplemental bundle, tab 5. And the particular bit we need to look at starts on page 86. Oh, sorry, the document starts on 86. We need to start on page 88. And it may be helpful to also have open the judgment at para 365, which is core page 135. This is where the judge is addressing Nokia. I mean, he in fact talks about the disclosure of Nokia in a lot of detail because it was relevant to the obviousness case. But we just need to worry about section 4, which he starts looking at the bottom of page 135, and that's the proposed signalling scheme. And what you can see under the heading 4 in Nokia is that the proposed resource allocation scheme contains various cell-specific input parameters, which the proposed algorithm will use as an input. So first of all, you've got static input parameters, and they are, it says here num f shift and num f shift. The first bullet point is a typo, and it should say num t shift, and the judge explains that, I think, at paragraph 366. And so num t shift is the number of cyclic shifts of block spreading code. And so if my lords recall from this morning, that's the orthogonal sequence, the Walsh code, whereas num f shift is the number of cyclic shifts of frequency domain Kazakh code. So that's the Kazakh or Zadov Chew sequence. And that has num f shift equal to 12. And then you've also got some what are called semi-static input parameters. The first one is res first, which is just the starting position, essentially. We'll see that in a minute when we come to the figures. And then you've got shift diff, which is the cyclic shift difference between the two implicit resources. And so as the judge explains, the shift diff, he says at paragraph 367, is the gap between the two resources. So it's the sort of mesh structure. And then I think you can go over the page and look next at figure 3, and that is reproduced in the judgment at paragraph 369. And we're particularly interested in the middle one of these tables, which the judge has referred to as B, or labelled as B. And what we see, first of all, above the tables is that num F shift in each of these is 12. So that's a Kazakh sequence of 12. And then you also see at the bottom of table B, the middle table, that num T shift is 3. And that is talking about the blockwise spreading code. And then underneath num T shift, you've got a reference to res first equals 30. And that's slightly confusing, but what it means is when you look back up to figure 2, that's where your first resource is going to go. That therefore that's where you start the numbering. So the first, so 30 in figure 2 is in the third column, 4 from the bottom, which is why when you look at the numbering in figure 3, table B, you start at 0, which is the first cyclic shift or the first grid that you're filling in, and you do that 4 from the bottom of the third column. And
now we come back to the question of the colour coding.
Yes, and my lord will see here that you've got some blue, and that's where the blue came from in that paragraph.
Well, quite so, but I can't see any explanation in this document as to what the colour coding represents.
I mean, my learned junior is telling me it reflects the way in which the columns are offset in figure 2. And so slightly bizarrely, you might think, if you look at figure 2, it goes 0, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 down the bottom in the first column. And then you might think, well, why isn't 12 at the top of the first column? And in fact, for reasons that I'm afraid I can't explain, 12 actually starts 1 square down in the second column.
Sorry, I've lost you. Where are we now?
Well, I was trying to
Oh, I see, yes.
explain what the blue bits are, or the blue boxes are about, and they're.
I don't know what they're about, but they actually just follow the matching numbers, don't they? On the axes. So for 36, you get it where it's 3 and 3. I'm not saying I know why it is, but.
Well, that's just where that's where you put 36 in your 36th resource in the grid. So you don't put it where you might think you put it, which would be at the bottom of the second column if you just filled them all in order. But in fact, you put it up there. But I don't think anything turns on this.
No.
Well, it may not matter, but one can see that the blue squares are always on the same diagonal.
Yes.
And one can also see that the mathematical relationships are different. So most obviously in table C, where it goes 47, 38, 41, 44.
Yes. We're not placing, just to be clear, we're not placing any reliance on the blue squares. But I can certainly try and find out overnight whether we can shed any more light on them. I don't think they featured at trial. So just checking whether I've explained. So yes, I think I've already explained that the way this works is because your res first equals 30, your first resource is going in the 30th position, and that's the 30th position as identified in figure 2, and that is why your first resource 0 is not to be found at 0, 0, but is to be found at 8, 2. mean, it's to be found in the third column, 4 from the bottom.
Yeah.
And you then, your numbering then goes 0, leave a space 1, leave a space 2, which is back up at the top of that column, and then the pattern.
Sorry, I'm obviously being very dense here, but why is that the 30th position? Because it's 12 plus 12 is 24 plus 8 is 32.
I think it's because you start at 0.
I think it's because it's 30 in figure 2, actually.
Yeah.
I don't know why it is, but that's because that's back to the blue again. But those are the numbered squares in figure 2.
So, I mean, you look at table B in figure 3 and you see that res first equals 30. And in order to work out where that is, you look back up to figure 2, which has numbering of implicit resources, and you see that 30 is in line 8, column 2, and therefore in table B you start at line 8, column 2 with your...
But the numbering in figure 2 is bizarre because it goes from 0 to 11, then 23, and then 12 to 22.
I think my lord must be right a moment ago that the blue line has an impact here. I don't know why, but it goes to 11, and then you start again on the blue at 12. You work down to 22.
Yes.
And then you use the top of the column for 23.
Yes.
And then you do the same thing, one shifted down, then goes 24 down, and then you go to
Yes,
the top.
exactly.
That's how it works. It's shifting the cycles of those 4 columns down one every time, for some reason. And this is just, and I think figure 2 is just an effectively arbitrary numbering of the blocks. It's all to do with the resource elements, blocks, or whatever they are.
I mean,
but neither of those things, whatever they are, rectangles.
The important point to see from figure 3, table 2, is that you have got, at least with the first 18 resources, you have got every other square being filled in. You've effectively got a 2 cyclic shift mesh.
And just to confuse this for a moment longer. So you're right, you go 0, 1, 2. And where is 3?
3 is in at 0, 0.
So do we assume that's to do with the blue in some fashion?
Yes, yes.
Yes, otherwise you'd go to 15, I suppose.
Yes.
So somehow it's shifted over to 3.
Yeah.
And then you follow the same pattern, 4, 5, 6, 7, 8. And then pick it up at the blue 9, 10. Yes.
If num t shift is 3, how come there's only one gap, one green square between 0 and 1?
Yes, num t shift is just how many columns there are. This doesn't tell you. So it's the blockwise spreading code, the number of blockwise spreading code. It is not the shift diff. So the shift diff is different and is not, as the judge explains at paragraph 370 of the judgment, it is not spelled out, but it's fairly easy to see that shift diff for A, B and C is 3, 2 and 4.
I was mixing up shift diff.
Yeah.
So there has to be some mathematical significance to the blue numbers, but anyway, or the blue line.
Yes, but in my submission it doesn't.
I don't suppose it affects this case, no.
So I think we basically looked at the points that the judge makes in paragraphs 365 to 370, and we just also need to look now at the end of section 4, which is in Nokia itself. It's on page 90 of the bundle, and there is some wording about a third of the way down or a quarter of the way down that says it's beneficial in some cases to allocate implicit ACNAC resources only from the limited code space. This is the situation when periodic CQI and ACNAC from different UEs are transmitted in the same resource unit. And so that is telling you, or is a reference to a mixed resource block. And that's a finding that the judge made, or he records that it wasn't in dispute that this paragraph discloses multiplexing CQIs and ACNACs in the same resource block. That's at 376 of the judgment. And there is also a reference to two other parameters: allowed T-shift, containing allowed cyclic shifts of block level code, and allowed F-shift, containing allowed cyclic shifts of frequency domain code. And what the judge explains at paragraph 374 is that allowed T-shift means that only certain of the blockwise codes would be used for ACNACs, and allowed F-shift means that only certain Kazakh codes would be used for ACNACs. And that's another parameter that's important when it comes to anticipation, because he records there that in practical terms this means that rows or columns in tables of figure 3 could be reserved for periodic CQI or ACNACs. So you can basically add an additional parameter in that says, right, I'm reserving this, and you can then use it for CQI, which of course is what we have in the claim. So just putting our case in a nutshell, before I get on to the detail of it, what we say is that the existence of these parameters that the base station can signal in Nokia means that it's clear that the mobile phone of Nokia is no different from the mobile phone of the claim. So the Nokia mobile can be induced to operate in accordance with the code multiplexing structure of the claim. And of course, on the judge's construction, we say that that means the mobile is adapted to work with the code multiplexing structure of the claim. Because if you can induce the mobile phone of Nokia to act in accordance with the code multiplexing structure of the claim, then it is no different from the mobile phone of the claim on the judge's construction. So all you have to be able to do is to tell it to use the code multiplexing structure of the claim. And we say that it's important to recall when you're considering this point, and this is quite tricky because you're sort of looking at it from the point of view of the mobile phone, although you're reading a document about the code multiplexing structure, that all that's necessary for the claim is that the mobile is adapted to operate in accordance with the CMS of the claim. And so the key question is whether the mobile of Nokia could be instructed to operate with the claimed CMS. So you've got to keep concentrating on the mobile. And that, to be fair, is sometimes a little tricky. And we say that the judge didn't always manage to do that. And that is one of the errors in his judgment on this point.
So this is the point you're making here, is that Nokia never, maybe a different place where you say it does or makes it obvious, but at least at this stage, you're not bothered whether Nokia actually tells anybody to configure a base station to send out the instructions that would make the pattern in the invention. Your point is that the mobile phone that you would make if you were putting this into practice would, if you sent it the right, using these parameters, if you selected the right ones, it would operate in accordance with the pattern that we're talking about.
Yes,
if you sent
exactly.
it the right instruction.
The pattern of the claim, exactly.
Yeah.
And so we come on now to the detail about the parameters that you need to signal. We need to go back to the judgment at paragraph 414, and that starts for page 144. And the judge is setting out our case here, and so it's quite helpful to take it from here. And at trial we ran two alternatives. First of all, the parameters are set out at 415, and secondly, the parameters are set out at 416. But on appeal, we just rely on those at paragraph 416. So you set num T shift as 4, that's the blockwise spreading code. Num F shift is 12, that's the Kazakh code. Shift diff as 2, that's your mesh. And then you use allow T shift to prohibit the fourth block level code, because otherwise you'd end up with 4 columns, not 3. And so that's paragraph 416. And then in addition to that, at paragraph 418, we say that there is a limit on the number of UEs, which is set as 18. And when you've got 18 UEs, then what you get is a mesh pattern. So at this stage, it's just a mesh of ACNACs with the 2 cyclic shift mesh. And as the judge explains, that would give a situation like that in the RS entry for 18 UEs in Nokia 002, but which would have a blank 4th column. Now, that's a little bit confusing because this is a reference in the judgment to a different Nokia document, 002, which was relevant for obviousness, but all the judge is saying here, and it's probably helpful to turn up Nokia 002, is that you get something that looks a bit like what's in Nokia 002 if you have all these parameters. So that Nokia 002 is at supplemental bundle tab 12, page 241. And he's talking about figure 2 at the top of 241 on the left-hand side. And that's what you get, but with an empty blank column on the end of it, a 4th empty column, if you have those parameters that we've just looked at paragraphs 416 and 418. Now, in addition to that, you'll recall that at paragraph 374, the judge explained that allowed T shift and allowed F shift allowed certain rows and columns to be left free.
Sorry, Miss Lane, I'm so sorry.
Sorry, don't worry, it is
maybe
very
I made a mistake.
complicated.
It's probably my fault. I'm looking at was it the top left or the top right?
Are you in Nokia 002?
Yes.
It's the top left.
That's fine. My fault. Top left.
I'm sure you're right about that, but can you explain to me why it's not top right? Because they both seem to be for 18 UEs.
Because we have got the parameter which the judge refers to in 416 at the end. Allowed T shift is prohibiting the 4th block level code. So in the one on the top right hand side, the 4th block level code is used because there are 4 columns in use.
Right, I see.
Whereas on the left hand there's only 3 columns in use. But I'm sure my learned friend would want me to say you notionally have to draw in an empty column on the left hand one.
Yeah, thank you.
So you've got to that stage where you've got your 12 rows, 3 columns, the 2 cyclic shift mesh, 18 UEs, your nice gaps in the right place. And then we have to go back to the judgment at paragraph 374, which we looked at earlier, which explains that you can use allowed F shift to mean that only certain Kazakh codes would be used for ACNACs, And so that means that they can be reserved, certain Kazakh codes can be reserved for CQI, as he's found at 374. So I explained that this part of section 4 of Nokia allows you to have a mixed resource block and allows you to reserve certain columns for CQI. And so we say in that scenario, the base station can decide to use one of those, the reserved ones, which aren't being used, and keep the others unused. And we say that was accepted by Optis's expert, and I need to show you a bit of evidence now, which is in Supplemental Bundle tab 29. At page 356 of the bundle, but page 388 of the transcript. And it's starting at line 7 to 4, starting at line 77, it goes through to 14. Do you agree, though, that it's technically possible for the base station to signal a loud F shift such that three consecutive cyclic shifts are not used for ACNAC, and that only the middle of those three is used for CQI instead? Yes, that could be done. That would result in an unused cyclic shift either side of the CQI. Yes, it would. And so we say...
Sorry,
Sorry.
Turns out I've lost you. I thought I had you, but...
So I'm on tab 29,
yes.
Page 3.
Oh, yes, I see. Yes. I'm
5, 6
looking
of
at
the
wrong
bundle,
part.
top right hand, 388 of the transcript.
Yes. Yes.
So we say that in the scenario where you've got the base station signalling all those various parameters that we've just looked at, then that results in a code multiplexing structure of the claim, meaning that in that scenario, on the judge's construction, the mobile phone is adapted within the meaning of the claim. So the Nokia mobile phone is just as adapted as the mobile phone, the LTE compliant mobile phone. And we then need to look at the judge's judgment. But before we get to that, does anyone have any questions? Because I appreciate this. This is a mind challenge, this part of the case. So going to the judgment, the judge dealt with this, and we've obviously looked at some of the earlier paragraphs setting out the facts, but the judge dealt with this at paragraph 419 onwards. And essentially our point is that what the judge says here, we say is inconsistent with his judgment on construction and infringement. So it either demonstrates that that his judgment on construction and infringement is wrong, or that the judgment on Nokia is wrong. And starting with paragraphs 419, 1 and 2, he talks about the CMS being the complete set of rules, and the fact that he says the rules as disclosed in Nokia can populate all the resources in the grid. So what he's talking about is the fact that he would say, and certainly Optis would say, you've ignored some of the resources because the whole grid is full in Nokia. And we say what the judge has failed to take into account in this is that the base station of Nokia can limit the number of mobiles to 18. And if it does that, then it induces the mobile phone of Nokia to work with the code multiplexing structure of the claims. And that is then the complete set of rules in that situation. And when the judge is talking about the complete set of rules, he must mean, we say, the rules at a given point in time, because otherwise that would be inconsistent with his approach on infringement. So just to make that point good, I want to go back again to paragraph 275 of the judgment where we've got some of the possible code multiplexing structures of the claim. And for example, we can see that the bottom right, this is core page 118, the bottom right code multiplexing structure, these are from the LTE standard, has got all the top 20 resources filled in with no cyclic shift mesh structure. So obviously, if you look at all the rules in the LTE standard, they are not all in accordance with the code multiplexing structure of the claim. So you must be looking at the code multiplexing structure as used at a particular point in time, because otherwise there wouldn't be infringement. And in addition, a similar point arises if you look at tab 20 of the judgment, which is again the technical essentiality, background for essentiality. At page 340, you can see at page 340 that in the standard, as shown at figure 8, you can have every single resource filled in.
I'm lost.
Sorry.
We're in the core bundle, aren't we?
Core bundle, tab 20, figure 8. It's just showing, my lord, some more code multiplexing structures which are within the LTE standard.
These are in this document is the agreed technical background.
Yes, that's what the document is, but not all of.
Not following. Got it.
So essentially, an LTE compliant mobile has rules which can populate all the resources, and so we say. Likewise, it therefore doesn't matter if the Nokia, in the Nokia case, you can populate all the resources. And in fact, this point is picked up again at paragraph 420 of the judgment. So I'm back on page 144 of the judgment, or 5. And the judge rejects the point that I've just made by saying that it's only possible if one looks at the aggregate effect of all the resources covered by the possible scenarios I addressed in infringement. And we say, well, you can't possibly be looking at the aggregate effect of all the resources because, in fact, only one of the infringement scenarios, or there may be more than one, but not all of them, give you a code multiplexing structure of the claim. And again, what's happening here, we say, is the judge is wrongly focusing on the code multiplexing structure rather than on whether the mobile can be induced to operate in accordance with the code multiplexing structure of the claim. So he's not concentrating on the mobile here wrongly. And he is most certainly in error when he says at the end of paragraph, or towards the end of paragraph 420, no one CMS meets the claim. I mean, it's just not at all clear what he means by that. There is a CMS with the parameters which we rely on, which meets the claim in respect of infringement, which is what he's talking about here. So this paragraph is just completely confused.
I understand how the point you're making about what the mobile phone uses or does, or whatever, or
Yes.
is adapted to do. But how does it work with the bit of the claim which requires the mobile to not do something?
Are you talking about the fourth column?
No, I'm talking about feature 1K of the claim. I understand. Your point is that if you sent the right signals to a mobile in a it doesn't matter whether it's rare or not, as a matter of principle, in a case in which there were 18 phones, if you sent signals, if you implemented Nokia,
Yes.
and you sent signals which Nokia contemplates as being possible among you can have any number from X to Y here and any number of A to B here, and within those there are choices you could make, and you had only 18 phones,
Yes.
then you would get a pattern
Yes.
which godlike looking down on it, you could say that pattern is the pattern,
Yes.
which is the same pattern as in the claim.
Yes.
I understand that.
Yes.
That's about what the phones positively do. The claim also requires the phones to not do something. And I don't understand how you've established that the phone has the capacity to not do something by showing what you've just shown us. And that's feature 1K.
Well, the phone. The question is, can you induce the phone to operate in accordance with the code multiplexing structure of the claim?
All I'm interested in is, can you induce the have you produced a claim, a phone within the claim? And my point is, the claim contains a negative feature, the feature of not using something.
Yes, and in the phone of Nokia with 18 UEs, you're not using every other cyclic shift. And when you have the parameter of allowed F shift, you're not using certain columns for CQI. So the gaps are there. The gaps are there, but both in terms of the two cyclic shift mesh pattern and in terms of the gaps before and after the CQI.
And what's in my mind is a question which arises from the fact that in the case in which there was another phone, the phone would not do what is not to do. If you see what I mean?
You mean if there's a plurality of mobile phones?
No, I mean if there were 19, your phone would then not do what it's required to not do.
But that's why, though, we say that Nokia can limit the number of phones to 18. And that's the base station can impose that limit, and there's nothing to prevent it from imposing that limit. And in that situation, the mobile phone is adapted to produce the CMS of the claims, which has all the gaps.
Right.
Because, as I pointed out at the beginning, you've got to concentrate on what the mobile phone is doing, because that's what the claim is about. And all you've got to do is be able to show that the mobile phone, the base station, when the base station transmits certain parameters, the mobile phone of Nokia will produce, or the mobile phones working in accordance with Nokia will produce the pattern. And that this happens essentially because the judge's reading of the claim is so wide, because all you've got to do is signal some things from the base station, which Nokia clearly shows you can do, and then your phone is adapted. I mean, that's the problem with the breadth of the claim.
It's tricky. I mean, take an irrelevant example. I mean, a monkey could write Macbeth. If you set a monkey with some mechanism for typing letters, then if you kept a monkey going long enough, it might happen on the wording of Macbeth. But it's not trying to produce anything that means Macbeth. And Nokia isn't trying to produce what this patent is trying to produce.
Well, I'm not sure it's relevant what it's trying to do if in fact the mobile phone does it. But also, this is nothing like the monkey, because Nokia clearly thinks that there is something. I mean, it clearly wants to produce a mesh with a shift diff of 2, because otherwise it would just
It's not
do
trying
all
to
the
clear.
resources one after the other without leaving the gaps. So
It's not trying to clear gaps for CQI, is it?
Well, if you recall, there is a reference to mixed resource blocks. That was the one we looked at the end of section 4. and it is telling you that you can clear, well, it is telling you that you can clear the resources to use from the CQIs. I mean, that was the bit at the end of section 4, I think it's allowed F shift, which means that only certain Kazakh codes are used, leaving the others free for CQI, which is precisely what's being discussed.
Just remind me where I find that.
Yes, sorry, let's go back to Nokia, because otherwise I'm probably paraphrasing it wrongly. So we're in Nokia, we're on page 90, and towards the top of that page there's the bit that starts, it's beneficial in some cases to allocate implicit ACNAC resources only from the limited code space. This is the situation when periodic CQI and ACNAC from different UEs are transmitted in the same RE.
Yes. That's it.
And so you signal those in order to block out bits. You say, well, I'm only going to allow ACNACs in certain places, which leaves the others free for CQI.
But you're not trying to clear an extra space to avoid interference.
Well, that's one of the points that the judge made, and I'm going to come to that in a minute. If my lord wouldn't mind,
Yes.
I'll carry on going through. So I think I'd got to 420, and then I hadn't done 419 paragraph 3, subparagraph 3 of the judgment, which is the fourth column. He says that the fourth column is a problem, essentially. And we say, actually, that the fourth column isn't a problem because this is the empty fourth column. First of all, because the first 3 columns would still fall within the scope of the claim and take the benefit of the invention. And in any event, the base station can decide what to do with this fourth column. And it's clear from the fact that this paragraph says usable, that it doesn't have to be used for periodic ACNACs.
That's about capability, isn't it? Isn't that what this case is all about? I mean, what the judge is finding is that although with the configuration settings, whatever you call them, of Nokia, you could, and you just looked at the 3 columns, you would see a pattern which looks like the claim. Actually, the fourth column hasn't gone away, and the fourth column would still be usable by the phone for something slightly different, which is periodic ACNACs. But it would be usable by the phone, which is the claim says it shouldn't be.
But the base station can just tell it not to use that fourth column.
Well, as I understand it, unless I've misunderstood it, what you've shown us the base station can do is tell it not to use that fourth column for these kinds of ACNACs. This signalling you're talking about isn't telling it not to use the fourth column for periodic ACNACs.
Well, what it says here is it would.
What it says where?
Sorry, carry on.
No, where? What are you reading from?
I'm reading from the judgment at the moment.
Okay.
So the judge said it would be usable with ACNACs, but that doesn't mean it has to be used with ACNACs. So the base station could say, don't use it with ACNACs.
No, I don't believe that's what the judge is saying. My understanding of what is written in that judgment paragraph sub 3 is that the judge is finding that the fourth column, even though it would be unusable for scheduled ACNACs, would still be usable with ACNACs which are periodic ACNACs. In other words, the signalling from the Nokia doesn't tell the phone that it can't use the fourth column for periodic ACNACs. That's what I understand the judge to be saying there. And so far I haven't heard you explain why the judge is in error there.
Right, so we've got 2 points, I think. The first point is just essentially, so what if it's being used for periodic ACNACs? Because you've still got the code multiplexing structure of the claim in the first 3 columns. And, if the LTE standard or an alleged infringement have the first 3 columns being used in the way that they're being used, with the cyclic shift and all the other characteristics of the claim, then it's pretty clear that Optis would still say that's an infringement, just because it's got an additional thing.
But I'm probably being stupid. Could not then one of the ACNACs come in the wrong place in the fourth column so as to muck up the CQI?
Well, it would still effectively take the benefit of the invention, we would say, for the first 3 columns. Or I mean, the key point about the mesh structure and so on.
I probably am being obtuse, but as you've shown in your visual representation, you have to have a clear line for the CQI. Now we've got a fourth column, so we've got a larger structure, but you still have to have the clear line for the CQI, don't you?
Yes, I mean this
Well,
point is really about the
isn't
CQI.
it? That's
Sorry.
the other point. I mean,
That's
might be worth disentangling these points. There's,
Yes.
to my mind, a helpful visual illustration in the respondent skeleton at core bundle tab 4, page 57. And this is based on the Nokia 002
Yes, exactly.
illustrations that we were looking at earlier. And on the right-hand side, they show the fourth column, which is the subject matter of 419 Little Roman 3. We've just been having that discussion.
Yep.
And the availability for periodic ACNACs.
Yep.
So that's one point. But then there's the other point, which my Lord Justice Newey was just put in, which is even disregarding the fourth column point, there's no gaps. So it's not a two-cyclic shift mesh, as the judge says. And why is he wrong about that?
Well, it's still a two-cyclic shift mesh in the first three columns.
But you don't have the gaps for either side of the CQI.
Oh, sorry. No, we haven't even got to the CQI at this stage, my lord. I mean,
right, okay, fine.
Sorry, I mean that is going to come in a minute because the judge also complains about that. But at the moment, the judge is just on the fourth column.
Okay.
And in relation to that, we've got 2 points. The first is, well, essentially, you've still got the CMS of the claim because you've got columns 1, 2 and 3, which are taking the benefit of the invention. And I think my Lord Justice Newey's point is, well, column 4 isn't taking the benefit of the invention. And we say, well, that doesn't matter because columns 1 to 3 are.
Okay, so to come back to the 2 points I was adverting to earlier. So I understand now. I'm sorry, I was being a bit slow. We do have the two cyclic shift mesh because it one sees the pattern 1 blank 2 blank 3 and so on. That's fine. I get that point. And as I understand it, your argument about the fourth column is this is infringement plus something else.
Yes. Well, that's one
argument. And the fact you've got the something else is irrelevant.
Yes.
And I can understand how that kind of argument can work. Undoubtedly, in principle, there's nothing wrong with that argument, except that, as my Lord Justice Birss has put to you already, here we have a negative feature in the claim, and I'm still not understanding why it works on this claim with this negative feature.
The negative feature being the not used for CQI feature.
It's not just that it's not used for CQI, because as you rightly pointed out in answer to my previous question, the judge deals with CQI as a later point in his analysis.
Yeah, 1K is both ACNAC and CQI.
Yeah.
Sorry, I didn't. Oh, 1K is ACNAC and sorry, can I just check which integer of the claim we're talking about?
1K.
1K. Oh, sorry, I'm looking at the wrong claim. Yes, I mean this isn't talking about this fourth column. It's talking about the gap after the CQI. It's not used for either the ACNAC signal or the CQI signal. We haven't got onto the CQI signal yet, and the fact that you've got to have a gap. So we're coming on to that when we get to paragraph 421. So at the moment we're just looking at the gaps are the one that we need at the moment are those in the 2 cyclic shift interval, the mesh at 1L. And I think what's being put to me is 1K plus 1N, which is, well, you haven't got an unused cyclic shift after your CQI signal. But we're not on to that point yet. We're talking about the mesh, and what might be said is because you've got the fourth column with ACNAX in it, you haven't got a 2 cyclic shift mesh because you have got a ACNAX in every single one of those spaces, potentially in the fourth column, and that's therefore not a 2 cyclic shift mesh, but that's a different point.
Yeah.
And in relation to this point, which is the fourth column point, we've already got the point which is, well, just look at the first 3 columns. And then the second point is, well, the base station doesn't have to use the fourth column for periodic ACNAX. It can decide not to do so. And in that situation, there aren't any ACNAX in that column. Alternatively, even if you say, well, the base station has to use it for periodic ACNAX, periodic ACNAX
Do you mean the base station or do you mean the mobile?
No, I mean the base station.
Okay.
In terms of sending the instruction.
Yes.
Yeah.
So the base station could just say, don't use the fourth column.
I'm not doubting you, Ms. Lane. I'm not aware of evidence that says that.
Well, this is the point where we say that what matters is what the mobile can be. The mobile of Nokia can be induced to do, and we say it can be induced by the base station sending a signal not to use the fourth column.
I don't understand this as lack of novelty. No doubt the base station could say, don't use the fourth column, but where's the disclosure in Nokia that says, don't use the fourth column?
Or at least a parameter which gives you a choice.
Well, there is a parameter that obviously says don't use the fourth column, and then there's the judge's finding that it would still be usable with periodic ACNAX.
So please show me the disclosure in Nokia which says that you can tell the mobile not to use the fourth column for periodic ACNAX.
Okay, there isn't a disclosure that says that. There's a disclosure that says don't use the fourth column.
And what it's talking about is scheduled ACNAX.
Well, that is what the judge found. Yes, but
You don't challenge that, as I understand.
no, we don't challenge that. That's right. So the other point I've got to make about periodic ACNAX is they're obviously, by their very nature, periodic. They're not happening all the time. So some of the time it won't be used for ACNAX, periodic ACNAX. And that is a further point. But I mean, the main point is just to say, well, just because that column is there and could be used for periodic ACNAX and is sometimes used for periodic ACNAX doesn't mean that you haven't got the code multiplexing structure of the claim in the first 3 columns. Let me go back to the judgment, and we're now on, I think, paragraph 421, which is the paragraph that we have been mentioning already to some extent because it's the paragraph about the CQI. And the judge says that had he been wrong about the points we've just discussed, the CQI feature of the claim would have to be considered. And he says a Newey according to
I'm very sorry. I know you're moving on, and
yes,
and all praise for not trying to move with expedition, but I'm still struggling to understand the first point. And can I go back to page 57 of the core bundle, where I was? And I understand your point that if it was a case of just adding a blank fourth column, you say that doesn't matter. Okay, and we've been over the fourth column point, but I'm still struggling to understand why it is that you say that the correct picture is in effect what we see in the left-hand diagram with the addition of the blank fourth column, rather than, as Optis contends, the right-hand diagram, which includes the fourth column.
I accept that there is a fourth column.
Exactly. I've got.
Yes.
I'm trying to move on back from that
I think,
point to
the
the first
answer
point.
to my Lord's question is that you need 18 UEs. Your point is that if there are only 18, then the first 18 fill up the yellow and they don't go in the white.
Yes, sorry,
That's
I
the
didn't
point.
appreciate that was the question being asked.
I don't know if that's the answer to my Lord's question, but I think that's the point.
But yes, we say there's an 18 UE limit, and so you only fill up the yellows and not the whites.
When you say an 18 UE limit, it has to be 18, does it?
Or it could be less.
Can it be less? You'll still get the lesses with less.
Yes.
I'm not sure that's right, is it? You wouldn't have the constant 2 cyclic shift if it was less than 18, would you? Not necessarily, at any rate. It only works because it's 18. Which doesn't necessarily adversely affect your point.
I mean,
Because your point is 18 is permissible.
yes, but if you had 12, for example, there'd also be a 2 cyclic shift mesh potentially. I mean, but anyway, 18 is clearly a permissible number.
But you're not told to go for 18.
No, you're not told to go for 18, but on the other hand,
You're not told that 18 has any particular significance, as I understand it.
yeah, but it is adapted to work with 18, or the mobile is adapted to work with 18. I mean, the mobile is, again, we're focusing on the mobile of the claim.
All right, thank you. Sorry, I interrupted you when you were going on to the CQI.
Yes, so the CQI is addressed at paragraph 421, and the judge is basically saying, well, you can't get the CQI feature with Nokia, and we say that that's not correct because, as I explained earlier, the base station has this parameter, allowed F shift, which means that it can decide to use only certain shifts for ACNACs, leaving, say, for example, 3 cyclic shifts free, which could be used, one of which could be used for CQI.
And sorry, can you remind me again where we see that?
Yes, so we see
I think
that.
you have told me more than once.
Yeah,
already.
no, it's absolutely fine. It's in the supplemental bundle at Nokia, page 90.
Yes.
It starts, it is beneficial in some cases, and allowed F shift allows you just to use certain cyclic shifts. And it explains why that's beneficial, because you can use the other ones for CQI if you've got a mixed resource block.
Sorry, where are we looking? Page 90.
90, about a fifth of the way down the page, it is beneficial in some cases. So it's the second, just above the second set of 2 bullet points.
Yes.
And the second bullet point is allowed F shift. And so the judgment explains at 376 that what is referred to at it is beneficial is a mixed resource block. And then it explains that you can just have it, this allows you to leave empty shifts, cyclic shifts, in which you can put 1 CQI.
So we've got.
I'm sorry, I don't understand this, because you're relying upon the judge's finding in 374, where he says rows or columns could be reserved for periodic CQI
Yes.
or ACNACs.
Yep.
But the point he's making in 421 is that there's no parameter to ensure a completely unused cyclic shift, which is what the claim will do.
And what we rely on is the fact that you basically use your allowed F shift that leaves the 3, by way of example, 3 cyclic shifts free. The base station can then signal a CQI, and there is no reason to say that the base station can't signal a single CQI, leaving 2 cyclic shifts unused, and that was the effect of the evidence of Mr. Bradford, Optis's expert, which was, yes, it's technically possible with Nokia to have 3 cyclic shifts unused, the rest are used for ACNACs, and then you use the middle one for CQI.
Yes, but where's the disclosure? The fact that you could do that with Nokia doesn't mean it's disclosed by Nokia. Where's the disclosure?
But again, the question is whether what is disclosed is a mobile phone which is adapted to do this. And we say, clearly the mobile phone of Nokia would be adapted to do this.
Have I got this right? What the judge is saying is that although you're right that Nokia says you can tell the mobile not to use certain cyclic shifts for ACNACs, Nokia doesn't say, and you can go on and use those cyclic shifts for CQI. Is that what the judge is saying? Whether you agree with it or not, is that what he's saying?
Well, we say that he's approached it the wrong way round, because what he should be asking is...
No, I misunderstood what the judge is saying. What the judge is saying is that you don't get the gaps.
Yes.
The judge is saying you can reserve rows for CQIs, but what you're not taught to do is reserve a row for a blank.
That's what the judge is saying. And we say, again, well, you've got to focus on what the mobile can be induced to do.
But he does, doesn't he? He says a UE, according to Nokia, has to be able to deal with multiplexing CQIs and ACNACs. So to that extent, he's with you. He is looking at what the UE is adapted to do. But what he's saying is it's not adapted to have a completely unused cyclic shift.
Yeah.
Well, we would say that's simply wrong, because the point about the allowed F shift parameter is it's all about saying you use these ones and you don't use these. And so you're starting off with 3 gaps in the example where you prevent use for ACNACs by using the allowed F shift. And then you simply put a CQI in one of those gaps.
But there's no teaching to do that, is there?
It's technically possible, and it's something that the mobile of Nokia could be induced to do, we say.
Okay. But just in case, I just want to make sure I'm not going mad. Nokia doesn't say anywhere you could reserve 3 cyclic shifts and use one of them to send CQIs and keep the other 2 blank.
No, it doesn't say that.
Your point is that you say that doesn't matter. You
Yes.
say you can reserve 3 three cyclic shifts, and that's all you need to be able to be something within this claim.
Yes.
The judge doesn't deal here with the point that my Lord Justice Newey made, is that there's an interaction between the CQI point and the 4th column point. Because these non-cyclic shifts presumably have nothing to do with the 4th column.
Well, we've blocked use of the 4th column.
I understand, but if you were using a periodic ACNAC in the 4th column, you could clash with a CQI, couldn't you?
Just exploring that point.
Depends where the gap is.
You can tell me that I'm entirely misunderstanding, which is very likely. If I go to Optis skeleton, paragraph 41, where we get those diagrams
Yes.
my Lord was referring to. For the claimed scheme to be capable of working, if you take the right hand of those diagrams, you have periodically to have clear lines across the 4 columns.
Yes, exactly. Across. It's across, not down.
Across.
Yep.
And you say, well, that can be achieved at any rate in the 3-column lattice, because you can give an instruction not to put anything into 3 boxes.
Yes.
But then you've got the right-hand column,
Yes.
where you'll get these periodic ACNACs cropping up.
Yes.
So is there anything to say that in the Nokia scheme you can stick an instruction in not to put anything into, say you've cleared line 4
Yes.
for the first 3 boxes. It's crucial then you don't get an ACNAC cropping up in the 4th line, 4th column.
In my submission, you've cleared the whole of line 4.
But
So
not for periodic ACNACs.
Well, you have. You've said you're not going to use line 4 at all.
Even though, so either we interpret the charge as meaning, well, you just can't use the 4th column for anything, or somewhere else one finds something saying that you can't use the 4th column even for periodic ACNACs. Because if you can, you're liable to find the periodic ACNAC coming into the wrong line, which you've otherwise cleared for your CQI.
Well, I'm just relying on the parameter in Nokia, which we've already looked at, which is the allowed F shift, which says that you're going to be able to effectively say, I'm only allowing use of certain cyclic shifts for ACNACs, and so as I read that covers the whole of the cyclic shift. It doesn't stop at the end of column 3.
So you'd have to clear the 4.
Well, you would. You're in my Lord's scenario where 4 is clear. You're just saying the only cyclic shifts I'm allowing for ACNACs are 1 to 3 and 5 to 12. So you're not allowed in cyclic shift 4 at all. So the blanked out gap goes across the whole of 1, 2, 3 and 4.
It's the difference between don't and can't, isn't it? A lot of this is about what you're showing in Nokia is it tells you to do something, and then implicitly, therefore, it's not telling you to do other things. But there's a difference between not telling somebody to do something and them not being able to do it.
My Lord, forgive me. Do you mind repeating that?
Yeah, the point you're making is, and I get it, I understand, is that what Nokia is giving positive instructions all the time. It's telling the mobiles to do things.
Yes.
What it never does is tells the mobile not to do things. It simply sometimes doesn't tell them to do things. And there is a difference between not telling somebody to do something and telling them not to do something.
Yes.
The claim, at least as I understand it, contains features about what the thing can do, but also contains features about saying what it shouldn't be able to do.
Well, it uses the words used and not used, and we would say.
And on this hypothesis, we're on you losing on your construction point. So it's about what's it capable.
Well, adapted to use then and adapted to not use, and we say that this would be in the scenario put forward by my Lord Justice Newey, where cyclic shift 4 is not available. It's because allowed F shift has told you that you're only allowed to use cyclic shifts 1 to 3 and cyclic shifts 5 to 12. So you can't be in cyclic shift 4. You're not allowed to be. So I'm not sure whether it's different that it's a positive or a negative instruction. You just can't be in that cyclic shift.
Because Nokia is only positive. It's only telling you what you should and shouldn't do in a particular context. It's not telling you what other things you can't do. That's the point the judge is making about period. Nokia isn't about periodic ACNACs, so it's not telling you not to do things with periodic ACNACs. And it's not. And when it tells you it can do something with whatever the opposite of implicit ACNACs are, that's what the word is. It's not telling you anything about what you can and can't do with periodic ACNACs.
Well, it's telling you can't put any kind of ACNAC into column 4 in this example.
Right.
Sorry, row 4. I think I've been misspeaking. I've been talking.
Well, I was talking about columns.
Oh, okay, sorry. Then let me take a step back. So I thought we were still on the point about whether you can block out a cyclic shift and use it for CQI. And so we were at cross purposes. I do apologise, my Lord.
Right.
So no, I mean, that's back to the column 4 point that we've already
Yeah,
debated.
and the point I was putting was that there was an interaction between that and the CQI point. Because you can block out 3 of the columns using the thing you're talking about, but it's not telling you anything about the 4th column.
No, but you're blocking out the entire row. Row 4 you're blocking out, and that includes all the way column 1, 2, 3 and 4. If you block out the entirety of row 4...
Isn't that you're only blocking out row 4
Yes.
from, I don't know what they're called, the opposite of periodic actnags. Because this is only talking about whatever they are. Not what they're called.
I will have a think about that, but my immediate submission now is that...
This is all talking about schedule. Nokia is only saying what you can and can't do with scheduled actnags. So it's saying you shouldn't use row 4 for scheduled actnags, but it isn't saying anything about periodic actnags. That's the point the judge is making in 419.3, and it relates not only to actnags but to the CQI.
Yeah, and he comes back to that at the end of 421, where he says there's no parameter that makes it possible to tell the UE not to use all of those for CQIs. No parameter to ensure a completely unused cyclic shift. And that's the point my Lord Justice Birss has just been putting about the difference between telling somebody you to do something and implicitly you may not, and telling it don't do it.
Sorry, my Lord was on paragraph 421 at that point.
Yeah.
Yes. Yeah. Well, I mean, my Lords, we've explained that our position is that you block out the whole of the row, and that means that it can then be used for CQI.
Can I just ask one thing?
Yes.
Am I right? There's a sort of tension in the discussion so far between what Nokia is teaching, because it isn't really teaching the claim, and on the other hand, as I understand it, your position is, well, if a phone were programmed in accordance with Nokia,
Yes.
then it would infringe because it would be capable of being instructed to do what is within the scope of the claim,
Yes,
regardless of whether that was ever thought of and regardless of whether that was ever taught.
Yes.
And so your position is the latter. Who cares about the teaching? A phone that was programmed in accordance with Nokia would be capable of doing what is infringing and therefore would offend.
Yes, I mean, it's going back to what I said at the beginning of this section of my submissions, which is that you have to concentrate on considering what the mobile phone of Nokia can be induced to do.
Yeah.
My Lord, let me just ask my learned junior something. My learned junior points out, and I hope I've made this point already, but perhaps I haven't, or if I have not very clearly, it's getting late in the day, is this, which is in the claim, in our submission, there isn't a difference between not doing something and being told not to do something, and it's just use or non-use. And so that difference isn't in the claim, and therefore it doesn't matter. If it's not in Nokia. So, my Lords, I was planning to move on to part 2 of the submissions, unless there are any more questions about part 1.
No, thank you.
And so, we basically are moving on to a different technical area now. And that's the way in which the mobile phone finds out which resource it should use on the push. And that could be done explicitly by sending a signal on the downlink to tell the mobile which resource it should use. But this would obviously use a lot of resource. And so it's done implicitly by inference from information received by the mobile on the downlink. And in this section of my submissions, we need to start by looking at something called the COBE agreement and construing or trying to understand what the COBE agreement means and what it tells us about the nature of this implicit signalling. And so we need to now turn to the COBE agreement, which is in the supplemental bundle at tab 14. And that's a sort of longish document, and we only need to look at a short part of it, which is at page 254, and there's a subparagraph 7.13.2 headed uplink control signalling. And then there is a bullet point under discussion, question, comment, decision. And this is the COBE agreement, just this line here against the bullet point. For non-persistent scheduling, the ACNAC resource is linked to the index of the control channel used for scheduling. And the first question that this court needs to consider is what this means. And in particular, there are 4 possibilities. And we've set these out in paragraph 86 of our skeleton argument, so it might be helpful to turn
Just
that
before
up.
you get into the 4 possibility, can I ask this question? The conclusion is drawn from a discussion which is contained in a different document which is referenced here, viz. R072472.
Yep.
Does that document assist on the issue of construction?
Well, the judge said and found, and we don't contest this, that you wouldn't look at the other documents. Let me just find, or the skilled person wouldn't look at them, so let me just find the reference to that.
Seems a little puzzling because at first blush, it's very difficult to understand how one can interpret that one sentence without knowing the context. And the context is not in this document, it's in the other document.
I mean, the paragraph I was talking about in the judgment is paragraph 181, and it's in the judgment core tab 5, page 100. And that talks about R1 072472 had suggested 2 methods, either in association with the control channel index or association with the downlink resource blocks, and wasn't clearly established what the latter was. In any event, the latter was not adopted, and both proposals are quite specific. And then the judge finds, I do not think the skilled person would be likely to go back through proposals leading to the COBE agreement, so the 472 document is not CGK or directly available to interpret it. And so that, obviously, we don't challenge that, and as I understand it, neither does the other side.
He goes on to say, it is consistent with, and in a broad sense, supports my clear impression that the reader of the COBE agreement would think it was a specific decision to use the channel index. So the judge does seem to be taking that into account.
Well, my lord, it's not the basis of his reasoning, though, because he is saying the other documents are not available to interpret it. And the problem is, once you start getting into underlying documents and other proposals, there are an awful lot of different proposals which go in different directions. So in our submission, you just need to look at what the COBE agreement says, and we say that is what the judge has found. I mean, I'll be coming back to that reasoning anyway, and also coming back to the that document, because I think it's a document that the other side rely on, and we say it just actually isn't that clear. And I will turn it up at that point. So just going back to the four different options and our skeleton argument.
So can I be clear as to what your position is?
Yeah.
Because I think what we've detected is a possible ambiguity in the judgment at this point, but we'll think about that further in due course. But leaving aside what the judge did or did not say, is it your position that in interpreting the Kobe agreement, we must disregard the 472 document, or is it your position that we can use 472 to interpret Kobe?
Well, my lord, we say that you simply look at the Kobe agreement.
So to be clear, your position is we must disregard 472.
That's my primary position, but I have a fallback position as well.
Just for completeness, as they say, your fallback position is exactly what?
Well, I want to just check something in my note, because I don't want to be going off at a tangent, but I'm pretty certain that I... oh no, okay. Sorry, I thought that I had dealt with this particular Park Val document, but I just want to check which document I do deal with. Sorry, one moment, please. Yes, sorry. I don't have a fallback position. My position is you just read the Kobe agreement.
And your justification for that is what? I mean, bearing in mind that, of course, the judge is, in this passage in his judgment, dealing with two different questions. One is common general knowledge, and the other is interpretation. And the fact that you might not go back through prior proposals, so far as common general knowledge is concerned, is one thing. But if we are concerned with interpretation of the Kobe agreement, why do you say we must disregard the document that is A, explicitly cross-referred to, and B, provides the context for the sentence in question, which on its face is not very easy, at least for the layperson, to interpret?
Well, what we're actually doing here is working out what is CGK. I mean, that is the point of looking at the Kobe agreement, and that was the point that the judge was addressing. But was CGK?
I'm baffled by this, because common general knowledge is one thing, interpretation of a technical document is the other. Now, is it your case the judge has erred as to fact in his finding as to common general knowledge, or is it your case that he has erred in law in interpreting the document?
Well, in his judgment, they are effectively one and the same thing, because
but they can't
he says
be. They're two different questions.
Well, he is looking at what the meaning of the Kobe agreement is, because his view is that the Kobe agreement is CGK. And therefore, in this case, the two things are equated in the judge's judgment. Whatever the Kobe agreement means, that is CGK. And
presumably what's happening, I'm just speculating a little, but presumably what's happening here is one starts from the proposition, is the document itself common general knowledge? In other words, was it common general knowledge to those in the business?
Yes.
So there was a thing which we're calling the Kobe agreement. Maybe it was even called that, I don't know, I've forgotten. and one might say the answer to that is yes, everybody knew there was one. Then one might say, as a matter of common general knowledge, what was the common general knowledge about the Kobe Agreement? And one can imagine a situation where everyone said, well, we go and look at it, and we read it without going back through the agony of trawling through all those emails, and what we think as a result of reading that is what is common general knowledge, and is that what the judge was doing? And in fact, as a matter of strict legal analysis, it may not actually matter what the true interpretation of this document is, because it's not prior art as such, it's not cited prior art, it's not a novelty reference, and it's not a contract. So it doesn't matter, even if it may be that the skilled person's common general knowledge of what the Kobe Agreement was is different from what the true interpretation of the Kobe Agreement is.
But also, before you answer, could I add in that at 176, the judge says it doesn't matter with its common general knowledge because the Kobe Agreement is referred to explicitly in both pieces of prior art.
Right.
Yes, but unfortunately it does matter when it comes to construction of the 810 patent, because the judge prays in aid his view as to what the Kobe Agreement means / what is the CGK, and I'll come back to that point in a minute. And he uses that to assist him in construing the particular part of the 810 patent, which is what we have to look at about whether the what CCE associated with a putsch means. So it does matter when we get to construction.
Right, but so as I understand it, you say that the relevant issue is common general knowledge, and the reason why that's the relevant issue is because it affects construction of 810.
Yes.
Right. Okay. But in that case, why is it a question of interpretation of the document?
Well, my lord, that's how the judge has addressed it, essentially. Because he looks at it and says, I do not think that the Kobe Agreement is ambiguous, and he's essentially looking at what the words mean. And we differ about what the words mean, or what the skilled person would understand by the words, because we say that they are ambiguous, we say they're not clear. And so when the skilled person...
I'm baffled by this whole debate, because I can understand it being a question as to what's common general knowledge and what's not common general knowledge. But I'm struggling to understand how it depends upon the proper interpretation of the document.
Well, because the Kobe Agreement is the thing from which the CGK is derived, effectively.
In which case you go back and find out what on earth the context was, and for that purpose you look at 472, because that provides the context.
I suppose, Ms. Lane, you could imagine maybe this is the analysis. I don't know. If it's about common general knowledge, when one says, all right, the skilled person knows there's a thing which we're calling the Kobe Agreement as a matter of common general knowledge. Then you say the skilled person looks at the Kobe Agreement to find out what the agreement is.
Yes.
The skilled person in doing that doesn't think it's ambiguous. Then then whatever they think it means is what is the common general knowledge.
Yes.
If they do think it's ambiguous, then you might think that they would go off into the 472 and figure out what it really means, but only if they thought it was ambiguous, which is sort of a bit of an odd way of interpreting documents as a matter of law, but maybe that is the way that the common general knowledge would work.
Well, I mean, just to be clear what we say that the Kobe Agreement has got two parts to it, basically. One part is about implicit signalling, and the other part is how you do the implicit signalling. And we say the part about implicit signalling is clear, so the common general knowledge is that there will be implicit signalling. And the part about how it's done is not clear. That's the second bit, the resources linked to the index of the control channel used for scheduling, and therefore that is not, because it is not clear, it's not...
But if it's not clear, then surely the skilled person would follow up 472 to try and get some clarity.
my lord, we simply, adopting what the judge has done, says that the judge has found that the skilled person wouldn't do it. So we're just going with the judge's finding here. And Optis doesn't challenge that.
But it makes sense that the skilled person might not do it if the skilled person thought it was unambiguous. That makes sense on the way the judge has approached it. The judge has found it's not ambiguous. In other words, the skilled person doesn't think it's ambiguous. I'm putting words into the judge's mouth. I'm not sure he ever put it that way, but never mind. And if a skilled person reads it and doesn't think it's ambiguous, then they wouldn't follow it up. That's all right.
Well, my lords, perhaps at this stage...
It was my lord's question, is my point.
Perhaps at this stage we can look at the positive points that we make in our case, and then I can come back to this point, because I think maybe when my lords see all the relevant points, it will all become clearer. So obviously I've foreshadowed the fact that one possibility is that the COBE agreement isn't clear, save that it involves some kind of implicit signature. And as I mentioned before, in paragraph 86 of our skeleton argument, we set out the other possibilities in terms of what the second part of the sentence means. So it could be referring to the index of the control channel element, could be referring to the index of the control channel candidates, or it could be referring to the index of the control channel. And those were three possible interpretations raised at trial. We say that the correct interpretation of the COBE agreement, and hence the common general knowledge, is that it's ambiguous, save that you're going to use implicit resources. And the reasons we say that are, first of all, that there was no...
Sorry, can you just try and help me as to what that means? I could understand a submission that said it's common general knowledge that you use implicit signalling and you stop there.
Yes.
But that's not your submission. Your submission is it's common general knowledge that you use implicit signalling and then it's ambiguous as to how you do it. That seems a bit strange.
No, my lord, if I said that, then what I meant is it's common general, because the second part is ambiguous, the common general knowledge is limited to the fact that you use implicit signalling.
I mean, you could have common general knowledge that said, I'm going to use implicit signalling and I'm going to somehow or other use the control channel or something to do with it, which is another way of, that's a sort of more positive way of describing ambiguity. What's wrong with that?
I mean, what the problem is, just to be clear, is that there wasn't a control channel index which was known to the mobile phone at this stage, and that is something which, in fact, the Optis's expert said, and I just want to go to the evidence on that so we can see what that was, and that's at supplemental bundle tab 29. Oh, sorry, tab 28 first of all. No, I'm now looking at the wrong place. Tab 29, page 365 of the bundle. Sorry, yes, my learned friend has just pointed out that this is actually the evidence of our expert at this stage. I am going to come to the evidence of Mr. Bradford as well. So the evidence of Mr. Edwards was as set out at the bottom of 526, starting from line 23, going on to 527, line 14. And it's actually referring to a cross-examination document which is in this bundle at tab 26 if my lords want to turn it up. It's a little bit confused at the bottom of page 526, but at the top of page 527, what he's saying is that the control channel number on the left-hand side, and that's talking about the document, but it's the downlink control channel, is only known to the base station because the UE does not know how many other control channels in use. Then again at line 10 on page 527, the witness says, I thought it would just be helpful because there were, I noticed in the transcript, possible confusion. Maybe people thought that the mobile could know the control channel number of the other mobiles as well, but they cannot, even know their own, let alone that of other users. So the mobile doesn't know the control channel number. And a similar point is made at supplemental tab 30. So in the next tab, page 389 of the bundle, perhaps it's a bit clearer here, at the bottom of page 621, we're talking about the Kobe agreement now. So line 22, transcript page 621, down to page 622, line 5. So in the answer, he says the index of the control channel is what is said, which I think I explained yesterday means something that is countable. As I explained yesterday, my point is it is known to the base station, but not to the mobile. The thing that is known to the mobile is the control channel elements. And this is not in dispute that the mobile doesn't know the control channel index. So it's clear, therefore, that the control channel index isn't going to work as a means of implicit signalling on its own.
Right. Why does that mean that the Kobe agreement doesn't mean that, though? I mean, I understand the point you've made is that on the state of the development as it was at that time, the mobile doesn't know what the index of the control channel would be. But that doesn't mean that you couldn't, when you built a whole system, use the index of the control channel. It just means you'd have to make sure that you had a way of telling the mobile phone what the index of the control channels was.
Yes, I mean, the difficulty that it gives rise to, however, is that you have to explicitly signal the control channel index because the mobile phone doesn't know it, and therefore you're rather defeating the object of having implicit signalling because you're having to add some extra explicit signalling.
But I understand your point is, you say that if you put this into practice, and even if you thought about it, you would realise that you couldn't do what you really wanted, you say. But that doesn't mean that that's not what this means. It just means that it wouldn't work.
Well,
that's like somebody writing down in 1750 what I'm going to do is make a plane that flies that's heavier than air. Well, you can't do it, but it doesn't mean it's not what they said.
Well, the further point is that Mr. Bradford himself said that it wasn't clear. And so I just want to turn up those references as well. So that's starting at tab 28, page 324. And it's transcript page 264, which is at the top right-hand side of page 324, line 7. And this is Apple cross-examining Mr. Bradford, Optis' expert, and saying Mr. Edwards says that there was no known index of the control channels at the priority date. He says, yes, it was not clear how this would be done at all. And so he then the question is, however, you go on to say at paragraph 46 of your second report that if the skilled person considered what this Kobe agreement was talking about, they would likely think it was the index of the control channel candidate. So that's another option. That's not the control channel index, that's the control channel candidate. And then returning to that point at line 23 on page 264, so so you say in your evidence that you think it was likely that the skilled person would understand COBE to be referring to the control channel candidate of this figure. And the answer from Optis's expert, line 2 on the next page, I think the point I was making was that it is just not clear what they meant at all. And just for completeness, read on to the end of line 7. He's then really getting into the question of obviousness, but he's certainly in that passage explaining that he didn't think it was clear what they meant, and that was a point that was made again on page 271, which is on bundle page 326, and at 271 it's lines 10 to 16. And basically he ends up by saying, so I think there was a lot of confusion at the time of what this control channel indexing meant. And then we've got another reference which is at page 274 of the transcript, which is page 327 of the bundle, line 18. We're talking about Panasonic here to start off with in the question. But then in the answer at line 22, the first idea, how it actually stated the COBE index of the L1, L2 control channel. What I was trying to get across is there was no agreed way of indexing a control channel. And my whole point is it's just not clear what an index of the control channel is based on what was known at the priority date. And then going further down that page, where there's more discussion of the COBE agreement starting at line 16, the question was, why are you referring to it in your evidence if it does not support your reading of the COBE agreement? I'm not sure I follow that point. Just describe the possible interpretations of it. So you are simply relying on it as a proposition that the text could have different interpretations. Yes, and it is not obvious which one it is. So we say...
Is that referring to Panasonic or to the COBE agreement, that last bit?
Well, I read it as referring to the COBE agreement because that was what was referred to in the question.
The reason I asked is that in 16 it says, why are you referring to it if it doesn't support your reading of the COBE agreement? So I took the it at 16 to be the Panasonic document. So I wasn't sure what the text then referred to in 21 was. Read as though it might be the Panasonic thing rather than the COBE agreement.
Well, my lord may be right about that. It is a little bit ambiguous, but certainly what he says in the earlier passages supports the point that the COBE agreement just isn't clear. And we say that that's also supported by the Panasonic document. That may be the Panasonic document that we were referring to, but I'm not sure because there are sometimes several documents. We can check that. But anyway, looking at the Panasonic document at tab 18, now this is a document that postdates the COBE agreement, so we're not saying that you can rely on this as an aid to construction of the COBE agreement. As you'll appreciate, our position is you just look at the COBE agreement, but it does show what people at the time were saying about the COBE agreement, and in particular if you look at page 276 of the bundle, that's the first page of tab 18, then you've got the introduction refers to the COBE meeting and the phrase that we've already read, and then Panasonic says, or the author of this document, however, the meaning of an index of control channel could have still different interpretations. This contribution provides a discussion of two alternatives of these interpretations and proposes the clarification. And then in the discussion, the two interpretations are set out at A and B. So the first one is ACNAC resources linked to the index of the L1, L2 control channel. And the second is that the ACNAC resource at B is linked to the index of the control channel element. And what is explained under the heading cons under subparagraph A is that additional signalling would be required for indicating index of L1, L2 control channel if line detection of UE is reasonable size. So that was the point I was making earlier, that if you're going to use the index of the control channel, then you need additional signalling. And as explained underneath B, since adding the index of L1, L2 control channel requires the same amount of overhead as explicit UL ACNAC resource allocation scheme, we propose to clarify that the ACNAC resource is linked to the index of the control channel elements. So this is all about clarifying what it means, because it's clear that it has two possible interpretations. It's not, as Optis suggests in their skeleton, amending the COBE agreement. It's talking about clarifying it.
This is what the judge called the polite document, was actually trying to reopen the argument and go back to have a control channel. And I understand it says what it says, but the judge's finding on that was, I think he called it a polite attempt to reopen the debate.
Well, there's no basis for that finding. I mean, that comes out of nowhere. I mean, I'm going to look now at what the judge did say.
And is that best done in the morning?
Yes. Yes, I mean, I'm afraid there's no way I'm going to get to the end of my submissions, even if we press on till 4:30. So it would probably not make sense to move on to this point, because I'm not going to finish it very quickly.
I mean, I assume that in terms of the 3-day scheduling, we're doing very well.
We are doing well. I mean, obviously it depends on how long my learned friend wants to address my lords for, but I would imagine that either with a very fair wind and my learned friend not saying as much as I have, we might finish tomorrow. Otherwise, we should be finished by, I would hope, lunchtime on Thursday, unless my learned friend is going to take quite a lot longer than I'm anticipating.
Well, as you'd anticipate, we certainly won't object if we don't use all the allocated time.
Yes.
So 10:30 in the morning.